morning to everybody. Thank you to the Attorney General. Obviously, also thank you to the law school who's done so much for us, as the Attorney General has mentioned. We're going to go through the Access to Public Records Act and the Open Meetings Act today during the PowerPoint presentation. Throughout the presentation, Laura and I are going to be referring to the bound book. We're going to talk about some of the pages that are in the bound book. Hope you to basically go through and learn how to use the law in conjunction with our PowerPoint slides. And hopefully that will help not just for today, but hopefully after today, learning to answer questions as questions come up. We've had questions in the past about sometimes the presentation didn't pertain to my public body. It was really focused on other public bodies. Let me start by saying that everything we talk about today is going to be applicable to all public bodies. All under the Open Meetings Act and public record law, all public bodies are treated the same, except for certain circumstances, mostly the school committees, and we'll emphasize those differences as we go forward. But for your purposes, all public bodies are going to be the same, whether you're a town council or a fire district or state agency. Our focus also is going to be today on what the law is. During the panel discussion, we may get into a little bit about what the law should be, but our primary focus today is going to be what the law is, not what it should be, what it could be, or what the requirements are. We're going to go through and highlight, we did this more last year and it was very well received, so we're going to follow the same type of format and focus on some of the past decisions for the last year. In doing so, obviously we're not going to hit every decision, we're not going to talk about every statutory provision, but we are going to try and highlight what happened in the last year and some of the more important issues that come up day in and day out. There were no legislative amendments the past year. There were lots of proposed bills, but none of them were enacted into law. There was one Rhode Island Supreme Court case, and we will talk about that as we go forward. We're going to start with the PowerPoint presentation. If I can get Joe in the back to dim the lights in the main room. And I'm just going to ask everybody to hold their questions until the end. We've got a whole half hour or 45 minutes to go into to that portion of the program. So we'll start with the public record law. And the public record law doesn't pertain to every single situation in the world. It starts with really two threshold questions. Is it a public body? Is the request being made to a public body? And is what you're asking for a document or a record? And you see here, that's the first threshold question. There's really two parts to the definition of a public body. It starts off broadly as any executive, municipal, legislative, judicial, regulatory, or administrative body of the state or any political subdivision. That's a fairly broad definition. I think people are pretty well aware of that. The nuance that we've had really in the last year or so is the part that you see here on the screen. The public body under the public record law also pertains to any other public or private agency that acts on behalf of and or in place of any public agency. So just because something may be a nonprofit corporation, you see the first case cited here, the North Smithfield case. That was a case we had in the last year where the North Smithfield Fire and Rescue Services provided, probably to nobody's surprise, fire and rescue service. They were providing fire and rescue service to the town of North Smithfield as well as some other towns via contract. They were a municipal agency. There was no legislative grant authorizing or creating the fire service. They were a nonprofit corporation. They had a contract with the town. The town paid them money through a contract, but the town had no other type of oversight other than enforcing the contract over the fire service. Despite all that, we found that they were a public body because of this provision. We looked at what their function was, what their duties were, what they did, and their duties were consistent with those of the municipal fire department. The contract laid out what their responsibilities were, and again, they were consistent with the municipal fire department, so we determined that they were acting on behalf of and or in place of a public agency, despite the fact that they were a nonprofit corporation. So be aware of that just going forward. When we get to the Open Meetings Act, Laura's going to talk about it, and we'll find that the definitions between open meetings and public records for public bodies differ a little bit, but be aware of that going forward. The other threshold question is, has a request been made for a document? And when I say a document or a record, that's defined very, very broadly. It's on actually page 9 of the bound book, the definition of a public body. I'm not going to go through the whole thing, it's a rather lengthy definition, but it includes more than just a hard copy. It could be a photograph, it could be an email, it could be some type of an electronic record, audio recordings. The list really goes on, and I think at some point in the definition it basically says, any other type of tangible item that's received or made in pursuit of the official function or something to that degree. So it's a very broad definition. The focus that we've had in the last year or so, and that we're seeing questions arise about, is just because a person's making some type of a request, are they requesting a record? Interrogatories, please answer these questions. Explain how the town arrived at this type of decision. Those aren't requests for records, generally speaking. The Access to Public Record Act doesn't govern those types of situations, so be aware of that. Having said that, at the same point, you also have to be very cognizant that we, as the Department of Attorney General, have interpreted it very broadly. There's obviously a pro-access function to the Access to Public Records Act, and there are no magic words when it comes to making an Access to Public Record request. The Attorney General made reference to the small white book which is online, and there's a sample request form in the back of that. And we make very clear in that request form that I'm requesting these documents. But it doesn't have to be that specific. Just because somebody uses the word explain, for instance, if that explanation can be provided through documents, provide those documents. That may very well be responsive and be consistent with the interpretation of the Access to Public Records Act. And actually, at this point, I was going to save this to later, but we also get questions, or we've seen situations where rather than responding through a document, a public body is responding through essentially an answer. To give an example, a request may be made for somebody's salary, which under the Access to Public Records Act is public. Rather than provide a document that provides that person's gross salary, the public body may just respond in a letter saying, so-and-so's salary is, X dollars. A lot of times that may satisfy the person making the request, but if we get a complaint on that, we would find a violation, and we have found violations on that, because you haven't responded through documents, and the Access to Public Record Act requires documents. The last point here is, we see here research assistance, and I promised you starting this off that we were going to talk about cases in the last year, and the first case I put up here is 2002. But we really haven't talked about this case before, and I think it's an important case because it talks about what the obligations are of a public body who's responding to a public record request. The Blaze case, Blaze versus Redlands, Operation Clean Government, made a request for Chief Judge Aragon's attendance records. This case went before Judge Hurst back in 2002. And in a fairly lengthy decision that kind of went through a lot of different aspects, Judge Hurst ruled that the records were exempt from public disclosure. We'll talk about the reasoning why a little bit later. But among the things that Judge Hurst was talking about was the type of records that would be responsive to Chief Judge Aragon's attendance records. And she talked about the dicta that, conceivably court orders signed by Judge Aragon would be responsive to the request, because if an order was signed by Judge Aragon on July 30th, it would evidence possibly that he was, in the courthouse that day. What Judge Hurst wrote in saying that even if those documents were responsive, the public body didn't have an obligation to provide the court orders because they weren't actually responsive to the request. She wrote, public bodies are repositories of records, not libraries, and their administrators are not research assistants who should cull, compile, or consolidate the data sought based upon their own idea of what is appropriately extrapolated from the existing records given to discernible objectives behind the request. I think a better example is a case that we did have this year. It involved the Abilene Fire District, and it's not cited because the Fire District didn't handle it this way, but I still think it's a good example going forward. That was a case where a gentleman had made a request over a 2 or 3 year period looking for certain open session minutes that evidence a type of vote or type of discussion on a particular topic. And the Fire District actually went through their minutes to find minutes that were responsive. They went through 2 years' worth of minutes to find documents that were responsive. A better way or a different way to handle that would have been to provide the gentleman making that request access to those open session minutes, and he could have made the judgment to determine whether or not they were responsive.